A very good evening and welcome to the eighth episode of Me-Arcone Queen, proudly powered by the Institute for Alternative Dispute Resolution, an organization dedicated to resonating peace, rebuilding trust, dialogues as a path to resolution. I'm your host Ananya Tyagi from Asian Law College, and it's an honor to guide you through today's discussion on the topic Neutral Ground, a deep driven into arbitration, mediation, and dispute resolution strategies across India's key industries with Mr. Sanjeev Nirmani, sir. We are privileged to be joined us today by Mr. Sanjeev Nirmani Goyal, a distinguished legal profession with over 32 years of expertise in ADR, consumer and commercial law. Over the course of his career, he has served as counsel, arbitrator, mediator, adjudicator, and consultant in commercial matters, working alongside the member of judiciary, including retired judge of Supreme Court and High Court. Mr. Nirmani has experience covered over constructions, FMCGs, insurance, medicines, telecom, and power. He specialized in conflicts, adherence, formulating effective business solutions, and achieving substantial savings in terms of cost, time, and resources for his clients. His approach integrates strategies, projects, planning with practical pleadings and documentations for complex disputes. A trained and certified mediator, he has actively participated in both national and international dispute resolution forums. His notable engagements include contribution to converted moods like WIS, JESUP, FTI, International Maritime Arbitration, and many more. His involvement extends beyond practice as he regularly mentors and coaches emerging legal talents, individuals as well as institutional terms. As serves as a judge in prestigious moot court competition, committed to promoting excellence in dispute resolution, Mr. Nirvani combines legal accomplishment with practical results oriented mindset. His long standing dedication to ADR and his proven ability to navigate complex dispute makes him sought after the expert in the field both in India and abroad. We welcome you, sir.
Thank you.
So, with your due permission, shall we begin with our Q&A?
Sure.
All right, sir. So, my first question to you would be on the infrastructure sector. Disputes often involve highly technical contracts, massive investments, and multiple cross border stakeholders. Based on your experience, what are some of the unique legal and procedural challenges you have observed in such disputes? And more importantly, how can ADR tool like arbitration or mediation be fine tuned to handle the confidentiality and technical complexity that the states demand? Do you find that involving technical experts early in the process involves effectiveness to ADR in such cases?
Okay. You see, the Indian government has recognized the need to reform how infrastructure disputes in India are handled, especially given the massive infrastructure investments and the
Right.
high stakes of both domestic and international investors. Several legislative measures and innovative approaches have been introduced to speed up dispute resolution and reduce the financial burden on the parties. One such key reform is the introduction of Commercial Courts Act in 2015, which aims to fast-track the resolution of commercial disputes, including those in construction, by establishing dedicated courts. These commercial courts follow specialized procedural rules, and although the system is still evolving, it is a step forward, creating a more efficient legal environment for high-value construction disputes. Another notable reform is the Mediation Act of 2023, which encourages pre-litigation mediation as a mandatory step before filing lawsuits in non-urgent cases. Mediation is gaining popularity because it allows parties to resolve disputes in a more flexible, informal setting, often leading to quicker settlements. The Act introduces structured timelines and makes settlements specifically designed to settle long pending disputes involving public sector infrastructure projects where the projects were stalled pending settlement of disputes. In the recently launched Vivad Se Vishwas scheme, contractors can settle their claims at discounted rates depending on the status of the dispute, such as whether an arbitral award has been passed or whether litigation is pending. This scheme is seen as a crucial step to unclogging the legal system and ensuring faster payments to contractors, thereby improving liquidity in the construction sector. About the experts, yes, involving technical experts early in the ADR process can significantly improve its effectiveness. Like we have a saying in Hindi, जिसका काम उसी को साजे और करे तो डंडा बाजे.
Right, sir.
So expert inputs can help parties better understand the technical aspects of a dispute, potentially leading to more informed and efficient settlements, especially in cases involving complex technical issues. So the reasons would be technical experts can explain complex issues in a clear and accessible way, helping both parties and the ADR professional, mediator or the arbitrator, whoever it is, grasp the nuances of the dispute. This shared understanding is crucial for finding a mutually agreeable solution. Also, technical experts can save some time, can sometimes identify potential solutions also that might not be apparent to those without specialized knowledge. This can lead to more creative and effective resolutions. That is about it.
Right, sir. So my second question to you would be on the power sector, where we often talking about how long-term contracts, government involvement, and public-private partnerships. Given these dynamic and how does arbitration help maintain investors' confidence, especially in situations where the stakes are high and the times span decades. Could you share us an example where arbitration played a role of safeguarding both commercial and public interest?
Sure. Sending such disputes to courts will result in huge delays due to immense backlog in the courts with not so good a resolution due to most judges not having domain knowledge. Arbitration helps maintain investor confidence by offering a faster, more confidential, and often more cost effective way to resolve disputes compared to the traditional litigation, especially in long term, high stakes situations. This is crucial for fostering a stable investment climate and encouraging both domestic and international investment. So, the key factors where arbitration uh, helps is faster dispute resolution. Since in domestic cases we have now a specific timeline of maximum of 18 months. Then the confidentiality, cost effectiveness, expertise and specialization of the arbitrators, enforceability, and simultaneously maintaining the business relationships between the parties, which in a traditional litigation would become very sore. Whereas when the disputes are settled by ADR, the parties are able to continue the relationships for future collaborations. And one case a case demonstrating arbitrators' role in safeguarding both commercial and public interest was in the case of Methanex Corporation versus United States. which involved a dispute under the NAFTA, that is North American Free Trade Agreement. The case highlighted how international arbitration can balance investor rights with a state's ability to exercise its police powers to protect public health and the environment. Uh, would you like the details of this case?
Or so can you
Ananya, would you? Okay. So the
right?
case was basically a Canadian company challenged the state ban on a gasoline additive under NAFTA, claiming it violated the treaty's provision on fair treatment and expropriation. So public interest aspect was the ban was enacted to address environmental and health concerns related to the contamination. So arbitrator's role there, the arbitral tribunal, while acknowledging the potential economic impact on Methanex, ultimately sided with the state, recognizing the state's right to regulate for public health and environment. So the balancing act came, the case demonstrated how international arbitration, despite focusing on investor-state disputes, can also consider and uphold a state's ability to act in the public interest, particularly in the areas like environmental protection.
Right. So coming to our next segment, which involves patient rights, with strict healthcare disputes can be some of the most sensitive regulatory compliance and sometimes allegations of negligence. When mediating such matters, how do you ensure confidentiality is maintained while still forecasting trust between the parties involved? Have you ever found that emotional factors overweight legal considerations in healthcare mediations?
As far as confidentiality is concerned, mediation as well as arbitration will
Right.
always maintain confidentiality.
True.
The proceedings are not in public and names of the parties are not called out as in regular courts. Most of the time, parties are assisted by lawyers, even for mediation, and coupled with the expertise of the mediator, trust prevails even if the parties are not able to arrive at a settlement. Though at some large mediation and arbitration centers, a list showing names of parties in cases to be taken up for mediation or arbitration on that day is publicly displayed. So confidentiality is breached to a certain extent
Right, sir.
on that count. However, healthcare disputes would generally not land for mediation.
Okay.
Nowadays, all hospitals and doctors have professional indemnity insurance. Almost all the time, the insurance company would not pay up till there is a court order, and the hospital or the doctor would not like to pay from own pocket, having taken insurance for the purpose. Yet, I have seen a case where a hospital and several doctors were involved in a claim for medical negligence. Some of the doctors, not wanting their names to be dragged before the Consumer Commission, settled out of court, and the remaining are still battling the claim before the Consumer Commission. In another case, during the proceedings before Consumer Commission, the parties, including the insurance companies of the doctors, agreed for attempting mediation. Even though the patient was agreeable to an amount for which the doctor was insured against a claim of almost 5 times the sum insured, the insurance company did not budge, and the parties had to go back to litigating before the Consumer Commission. So, coming to the emotional factor as against legal considerations. In healthcare mediations, emotional factors and legal considerations are both important and often intertwined, with neither necessarily outweighing the other. While legal frameworks provide a structure for resolving disputes, emotions significantly influence how parties perceive and respond to those frameworks, ultimately impacting the mediation process and its outcome.
Right, so. So the another sector which is insurance, a sector where disputes often hang on policy warning delays in claims, settlements, or even allegations of bad faith. In your view, how can mediation or arbitration help speed up resolution while still preserving the often fragile relationship between the insurance and the policyholders? Do you think that the industry is ready to embrace pre disputes ADR clauses as a norm?
No, invariably, all insurance companies are very large corporations and they have strict norms for sticking to the policy wordings and for abiding by the survey or investigation report submitted by the experts. It becomes rather impossible for their managers to deviate from the policy wordings and the expert reports and make any substantial concessions in favor of the insured. Thus, claims not involving small amounts do not get settled in mediation. Almost all unsettled claims come to be agitated before the consumer commissions. Arbitration is also generally not resorted to for insurance claims because the arbitration clause in the policy gives the power of nominating the arbitrator to the insurance company.
Right.
Now, after the latest law on nomination of arbitrator, barring unilateral nomination under the Perkins case before the Honorable Supreme Court of India, this impediment to arbitration was taken care of. But since the arbitration clause provides for ad hoc arbitration, the claimant is left to first address a notice of demand, then address a notice of arbitration, and then seek nomination of arbitrator from Honorable High Court under Section 11 of the Arbitration and Conciliation Act, involving high, if not substantial, expense of time and money even before the arbitration has commenced. So, as for industry being ready for pre-dispute ADR clause, I don't think pre-litigation ADR will be a good idea for consumer cases. However, pre-litigation mediation has been made mandatory under the Commercial Courts Act, and it needs to be seen as to what percentage of mandatory mediation cases get settled before reaching the court.
Truly agreed, sir. So now finally coming to the last sector, which is known as the FMCG for its fast moving nature and importance of consumer trust. Disputes here can be range from suppliers disagreements to consumer protections issues. From your experience, how do factors like time, sensitivity, and brand reputation influence whether a company opts litigation or ADR? Have you ever seen cases where the speed and privacy of ADR made a reverse differences in protecting the brand uh, image?
Okay, for this, we will have to segregate the B2B from B2C. Disputes relating to supply chain, which are B2B, will need to be settled by ADR due to the time sensitivity and brand reputation might not be a factor that will matter much. Also, invariably, all the supply chain agreements will have arbitration clause mandating arbitration, even if the arbitrator has to be nominated by petition before the Honorable High Court under Section 11. Consumer disputes, on the other hand, would be brought before consumer commissions by the consumers, hardly making any dent on the brand reputation being individual cases. It is generally not worth the while for the company to settle small or individual disputes through ADR. However, there could be class action consumer matters for a major defect or shortcoming in the product, which could result in severe damage to the brand reputation requiring timely damage control. In such cases, it will always be good for the company to settle through mediation. As for some cases, Almost none of the cases resolved through ADR would see the light of the day for the public due to the confidentiality, because those are all decided behind closed doors in mediation and arbitration. So we won't know about much of many of them. Even if I have conducted any such cases, I am bound by confidentiality to not disclose the details to anyone.
Completely agreed.
However, I'm not sure if you remember, about 20 years ago, there was a case where worms were found inside chocolate bars of a leading brand.
Yes, sir.
Apparently, that was resolved by ADR because nothing was heard about the case later on. And all that we got to know was damage control done by the company by improving the packaging and making huge publicity about the better and secure packaging.
Right, sir. Okay, so that's how we come to an end of today's podcast. Mr.
Yeah.
Nirvani, your insights really highlights how ADR isn't one size fits for all solutions. It has to be adopted to the sector, the stakes, the human factors involved. Thank you for taking us through this journey across industries. On behalf of our team, the Institute for Alternative Dispute Resolution, I extend our deepest gratitude to Mr. Sanjeev Nirwani, sir, for joining us today. Your remarkable journey, profound insights, and dedication to justice have truly enriched this conversation. Thank you for sharing your time, expertise, and passion with our audience. It has been an absolute privilege to have you with us, sir.
Thank you, and it was my pleasure too. Thanks a lot.
Thank you so much, sir. That's all for today's episode of Season 9, Episode 8 of Me-Arcone Queen. Until our next podcast, stay curious, keep exploring, and continue pursuing knowledge. Thank you for tuning in. Thank you so much, sir.
Okay. Bye. Yeah.